attorney Laura Anthony, founding partner of Legal and Compliance, a corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about Regulation A. A question that the SEC and practitioners continue to discuss is whether Regulation A is really a private offering or a public offering. The legal nuance is that Regulation A is an exempt offering under Section 5 of the Securities Act of 1933, and that has caused confusion and the need for careful thought by practitioners and the SEC staff alike. So far, it appears that Regulation A is treated as a public offering in almost all respects, except as related to the applicability of Securities Act Section 11 liability. Section 11 of the Securities Act provides a private cause of action in favor of purchasers of securities against those involved in filing a false or misleading public offering registration statement. Any purchaser of securities, regardless of whether they bought directly from the company or secondarily in the aftermarket, can sue a company, its underwriters, and experts for damages where a false or misleading registration statement has been filed related to those securities. Since Regulation A does not technically involve a registration statement, it is not considered a public offering for purposes of Section 11 liability. Securities Act Section 12, which provides a private cause of action by a purchaser of securities directly against the seller of those securities, specifically by its language imposes liability on any person offering or selling securities under Regulation A. The general anti-fraud provisions under Section 17 of the Securities Act, which apply to both private and public offerings, also apply to Regulation A. When considering integration, the SEC has now confirmed that a Regulation A offering can rely on Rule 152, such that a completed exempt offering, such as under Rule 506B, will not integrate with a subsequent Regulation A offering. Under Rule 152, a securities transaction that at the time involves a private offering will not lose that status, even if the company subsequently makes a public offering. The SEC has also issued guidance that Rule 152 applies to prevent integration between a completed 506B offering and a subsequent 506C offering, indicating that the important factor in the Rule 152 analysis is the ability to publicly solicit, regardless of the filing of a registration statement. However, in a nod to its technical exempt status, as mentioned in a prior LawCast in this series, Item 6 of Part 1 of a Regulation A Form 1A, which requires disclosure of unregistered securities issued or sold in the prior year, must include a disclosure of all securities issued or sold pursuant to Regulation A in the prior year. On the other hand, Regulation A is definitely used as a going public transaction, and as such, it is very much a public offering. A recent SEC white paper refers to Regulation A as a mini IPO. Securities sold in a Regulation A offering are not restricted and therefore are available to be used to create a secondary market and trade, such as on the OTC markets or a national exchange. Tier 2 issuers that have used the S1 format for their Form 1A filing are permitted to file a Form 8A to register under the Exchange Act and become subject to its reporting requirements. A Form 8A is a simple registration form used instead of a Form 10 for companies that have already filed the substantive Form 10 information with the SEC. Upon filing a Form 8A, the company will become subject to the full Exchange Act reporting obligations, which is a prerequisite to making application to trade on a national exchange. I'm attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.